Hello friends, a very good morning to all of you. Today we are going to discuss about a topic that relates to um, a Hollywood or a Bollywood movie. You may have seen in the movies that especially in Hollywood movies when the police arrests an accused, it is bound to say, you may have seen it in the movie also, that the police actually tells the accused that you have a right to remain silent, and anything that you are saying can be used against you in the court of law. However, similarly, in the Bollywood movies, the police just starts beating up the accused and makes him sign a letter or asks him to confess the crime, and based upon that, they serve the justice. The first instance, the instance of Hollywood is correct, and the second instance in which the police is beating the accused and taking statements from him and serving justice according to that statement, it is absolutely nonsense. Okay, so let us see what is this all about and why we are discussing Bollywood movies and Hollywood movies here. So anyways, so what is self-incrimination? So this self-incrimination actually means testifying against yourself. Okay, so the police, when it arrests you, they cannot ask you, they have to tell you that you have a right to remain silent. When they ask you questions, you have a right to remain silent, and they cannot take out any statement from you based upon which they can pursue the law. They can uh, pursue this case in the court of law. So, which means that they cannot take out any evidence from you, or they cannot use your statements as an evidence in the court of law. Does any other authority have any power to use your statements in the court of law? Yes, the magistrate has the power to use your statements in the court of law, but that too would only happen if you want to give the statement. You cannot be forced to give any statement to a magistrate. You can remain silent even even in front of a magistrate. You cannot be compelled to make any statement, because a statement made by you in front of a magistrate will be counted as an evidence, and that evidence can be used in the court of law. So why we are discussing this, why we are discussing self incrimination, why, how this topic has come into light? It is in news because recently there are some cases of drug smuggling in Bollywood, and one of the accused person, uh, from whom the NCB was making an inquiry, that concerned person has made an allegation against NCB, that is Narcotics Control Bureau, that the officers of Narcotics Control Bureau tried to uh, influence him in making a particular form of statement against a famous Bollywood director. I would not go into names. You can read it yourself, because I'm not going to indulge myself in controversies. I'm just discussing this topic with you. Okay, so what is self incrimination? So, as I've told you, this is about collecting evidence through the horse mouth. And now, why I'm saying horse mouth? Because the accused person in a crime is the person against whom the police has to find evidence to prove that the accused person is actually the criminal. So, under under any law in any country, most of the democratic countries, a person charged with a criminal offense cannot be compelled to testify against himself, okay, or to confess guilt. He has a right to remain silent, or the right against self incrimination. So self incrimination is what? Test Right against being a right against uh, testifying against right against testifying yourself. So you do not have to make any statement against yourself. Okay, so you have a right regarding that. So it is not just in international law, it is also present in the Indian Constitution. So Article 20 subsection 3 of the Constitution also provides that no person accused of any offense shall be compelled to be a witness against himself. Okay, so this provision is also a part of the basic law, a part of the Constitution, and not just a part of the basic law of the country. Okay, so why we call it Miranda rights or Miranda warning, that you may have seen in the Hollywood movies, because there was a case in 1966 in the United States Supreme Court. The case was called Miranda versus Arizona. Arizona is a state in the United States of America, according to which the judgment made it obligatory for the police to inform the person whom they have taken in custody that they have a right to remain silent and anything they say can be used against them in a court of law. So similarly, after that, you may have seen these statements being made by the police officers in Hollywood movies or English movies. Some, these rights are also there in our Indian law, as you have seen in our constitution, and subsequently they have been also um made statutory in the form of Indian Evidence Act 1872, which states that confessions obtained through inducement, threat, or promise are irrelevant in a criminal proceeding. So you have a legislative right also. You have a statutory right also. Apart from the constitutional right of Article 23, you have a statutory right also to remain silent. And it says that any statement made in front of the inquiry officer, which is generally a police officer, is inadmissible in the court of law according to the Indian Evidence Act. But if any voluntary confession, the term here is voluntary, if you want to, if you are an accused, if you want to voluntarily say something and which you think, which you believe and which you want to be taken as an evidence in the court of law, then you would have to make that statement not in front of the police but in front of a magistrate, who is also bound to tell you that any such statement, that you're not bound to make any such statement, and such statement can also be used against you in the court of law. Okay, so similarly, if you remain silent, then it's okay. You can also remain silent in front of a magistrate, but if you make a statement, then magistrate will record it as part of an evidence that yes, this person has made a statement against himself that he has committed this crime. So why we have done it? Just uh, because we have uh, realized that in some cases the Bollywood movies can also be true, that police can use torture techniques to obtain uh, confession through coercion from an accused. But because the court of law assumes that if a police has taken some statements, then there is a possibility that the police force may have used coercive instrumentalities or coercive techniques in obtaining such statements. But when the same person voluntarily confesses his crime in front of a magistrate, then the court assumes that all such confessions have been made voluntarily by the accused and he has confessed to the crime, then all such statements are admissible in the court. Okay, so you have to understand this distinction, that no statement made in front of the police is admissible in the court, and a voluntary confession in front of a magistrate can be used as an evidence against the accused person. Okay, but there is also a catch here. So let us assume that you made a statement in front of the magistrate because police said that we will threaten your family and all that. So just say what we are saying to you in front of the magistrate also. So you say that yes, I'm willing to make a statement. You give your voluntary approval and you make a statement in front of the magistrate. But then you have another filter here. You can retract your statement in the court of law. Only then and at that point the police has to give supporting evidence that the statement made by the concerned accused in front of the magistrate was not based upon any coercion by us, because we have this supporting evidence. So in case your statement the statements made by you in front of the magistrate, which you may have retracted later in the court, if the police finds some supplementary evidence or supporting evidence to that statement, then court can accept that statement to be true and you will be tried according to the statement and the supporting evidence. Okay, so is that clear to you up till now? So, but is there any exception in this case? That is there any law which allows the police officer to obtain evidence through statements from your side? From your side means from an accused. Is there any exception to this case? Yes, there is. There are many actually. Actually, when the laws of terrorism, TADA and POTA, Terrorism and Disruptive Activities Prevention Act, it was passed in mid 1980s and it remained in force till 1995. Similarly, POTA was enacted in 2002 and it remained active until 2004. What were the controversy around these surrounding these laws? That uh, these laws sanctified the statements given by the accused in front of the police officers also. So the police there were allegations that some police officers were misusing these laws and they were arresting innocent people and they were using coercion to obtain some statements against them. They were using self-incriminating statements, and because the statements made against themselves were admissible in the court, these innocent they were allegedly innocent. These allegedly innocent people were tried under the acts of terrorism. So there were controversies in such laws, so they were repealed later. But today there are similar anti-terrorism laws in the states of Maharashtra and Gujarat, and there is a debate and discussion over over a similar law in the state of UP also, where they have made incriminating evidence, self-incriminating incrimination legal in case the statements are made in front of a police officer above a specified rank. Let's say above a specified rank of superintendent of police or deputy superintendent of police. So there are some clauses here, but basically they are making a police officer capable or uh, giving them powers at par with a magistrate in such laws. Okay, so in the acts of terrorism or the legislations related to terrorism, there are exceptions here. Similarly, there is a controversy in the NDPS Act also. The NDPS Act is the Narcotics Substances and Psychotropic Substances Act, under which all the cases of drugs are tried in our courts. So there is a section 67 which says that the officer who is making the inquiry has the power to call for information from any person or examine him during an inquiry. So now the term here used is officer. Now which officer will be empowered to take such information? Will it be the police officer or the magistrate? So some people say that the term officer here means the police officer. So in case the term here, the term police officer is valid here, then the police officer can uh, force you to self-incriminate. But in case this term is not synonymous with the term police officer, then the similar provisions of Indian Evidence Act will apply here. Okay, so this case is under the supervision of Supreme Court at this moment, and there will be a judgment specifically to this NDPS Act and Section 67 of this NDPS Act very soon. And this judgment is actually a revised judgment of a larger bench, which was made in 2013 also. So in 2013, while examining the legality of this section of NDPS Act, the Supreme Court in Tufan Singh versus State of Tamil Nadu case said that the term police officer is also not defined in the Evidence Act or the CPC. So they are saying the Supreme Court said that the actual term police officer under the Indian Evidence Act or the Criminal Procedure Code is also not defined under these acts. So this officer, this term police officer or this term officer should be assessed from the perception of the common public. So when you have to see what does the term officer in any of such acts means, then you have to see what will be the common public perception about this term. The Supreme Court said in 2013 that this term officer is actually the term which relates to the common public perception. What the public would see it, what any general public would see it, this term is actually that officer. So the common general public perception would obviously be the police officer. So this judgment did not clearly specified it, but it said that it defined the police officer in some vague terms. Okay, so it also said that this person should be capable of exercising influence or authority over a person from whom a confession is obtained. So in this case of NDPS, this officer is obviously exercising influence and authority over this person whom he is inquiring. So this term, according to the so this term in section 67, the term officer in section 67, according to the 2013 judgment, is actually the term police officer. If we just have a rudimentary understanding of this term according to the 2013 judgment, then this term officer under the section 67 of NDPS Act would be the term police officer. But for greater clarity, the case has been referred to the Supreme Court, and the larger bench would decide upon the term police officer itself. Okay, because this term would have a direct or indirect repercussion on this act also. So recent in the coming few times, the judgment would be out, and we would see the implications on this term in this term actually, the term police officer. And once we get a clarity of over this term, then we would be able to understand the term officer under the section 67 act 67 of the NDPS Act. So this topic was related to the recent uh, cases of drugs in Bollywood, and this term is very important in terms of your both your prelims exam or your polity GS2 polity section. It can also be asked from you in terms of ethics via a case study. So you will have to know these basic terms for your own clarity. Okay, so thank you friends, this was our topic for today. We'll meet next time with another topic. Until then, have a nice day.